Hi friends, welcome to my lecture on Law of Contracts as under Indian Contract Act 1872. In this lecture, I'll be covering important concepts of law of contracts, which will definitely help you in your LLB examination. I would also suggest you to make your notes during this lecture as it will help you in your exam time. Indian Contract Act 1872 is a big act, so be prepared to spend some good amount of time on this. So let's begin without wasting any time. Let's quickly look at some important information about Indian Contract Act 1872. The Act has total of 238 sections divided into 10 chapters. The Act extends to whole of India except the state of Jammu and Kashmir. The Act came into force on 1st September 1872. Now let's take a look at the scheme of the Act. Section 1 to Section 75 covers general principle of law of contract. Then the Act talks about specific kinds of contract. Section 124 to 147 talks about contract of indemnity and guarantee. Section 148 to 181 talks about contracts of bailment and pledge. Section 182 to 238 talks about contract of agencies. Now, the most fundamental question of law of contract. What is a contract? In general terms, we can say a contract is an agreement. That is, when two persons agree on something, it is a contract. But can an agreement really be a contract always? Let's take a look at one example. Mr. A enters into an agreement with Mr. B and agrees to kill Mr. C for 25 lakh rupees. So is this an agreement? Can we call this a contract? Of course, this is an agreement. Two persons have agreed with each other, but is it a contract? Can we call it a contract? No, but why? See, not any kind of agreement can become a contract. To be a contract, the agreement must be enforceable by law. Agreement to kill someone cannot be enforceable by law, hence it cannot be called a contract. Okay. Now, as per section 2H, an agreement enforceable by law is a contract. That's the definition given under the Act. Friends, it is important to remember the sections of some important definitions under the Act. This will help you fetch more marks in the exam. So the contract is defined under section 2H. Okay. For a contract, apart from an agreement, there must be a legal obligation under the Act, under the agreement. Right? If there is no legal obligation, then it is not a contract. So two important elements of contract are: first, there should be an agreement. Two persons should agree on something. Second, the agreement must create or intend to create a legal obligation. Right? Let's take an example. Husband promises to wife to buy her a sari if she sings a song. Wife sang, but husband did not buy her the sari. Is this a contract? Why or why not? Take a minute, think over it, pause the video, and then give your reasoning. Right? Well, friends, of course, there is an agreement between husband and wife, but still it is not a contract for the simple reason that the intention to create legal relations or legal obligation is missing here. Wife never intended to take her husband to court because of this. She may fight with her husband, she may not speak to him for a few days, but she never intended to file a legal case because of this. Right? Okay, so these are some key points from our last lecture. You can pause the video and make note of this. Okay, so let's move on to the next topic. What is an agreement? Okay, so I spoke about agreement in my previous lecture. Now let's understand what is an agreement. Well, agreement is nothing but a promise. As per section 2E, right? I'm emphasizing the section number so that you remember it. As per section 2E, every promise and every set of promises forming consideration for each other is an agreement. right? You may not understand some words right now, like you may not understand what a consideration is. I'll get to this term later on, right? So in simple words, this means a promise to give something to the other party and get something from the other party. That is an agreement. For example, Mr. A promises to Mr. B to sell his car for 1 lakh rupees. This is an agreement, right? Now here both parties are giving or getting something. Mr. A is giving his car to Mr. B. On the other hand, Mr. B is paying 1 lakh rupees to Mr. A. So this is called consideration in simple terms, which I will discuss in my later slide. Alright. Now, what is a promise? Friends, agreement and promise mean the same thing, but they have been defined differently in the act. So it is important to make note of both the definitions. But if we talk in general terms, agreement means promise only, right? So what is a promise? Well, promise is nothing but an offer and its acceptance. When you make an offer and that offer is accepted, then your offer or your proposal becomes the promise. Now let's take a look at the definition. So section 2b defines promise, which says when the person to whom proposal is made, that is when an offer is made to a person, signifies his assent thereto, that is the person to whom offer is made gives his acceptance to the offer, the proposal is said to be accepted. That is, the proposal or the offer is accepted. The proposal when accepted become promise. That is, once the offer is accepted, it becomes a promise. Simple. Somebody makes an offer, you accept an offer, it becomes a promise. If somebody makes an offer, you reject the offer, there is no promise, there is no agreement, right? Here, promise and agreement mean the same thing. Please remember this. It is also important to note that when you are quoting any section, then try to give the exact definition. When you're quoting something in inverted commas, give the exact definition. I would suggest you to break down the definition into smaller parts. For example, I have broken down this definition of promise under different lines. So I would suggest you to do the same. It will help you memorize the definition better. Okay. Now, when does an agreement comes into existence? What is the first step in forming an agreement? Well, friends, agreement is formed when one party gives an offer and the other party accepts it, right? That's how you enter into an agreement. There is an offer, and when the offer is accepted, it becomes agreement or promise, right? So this is how agreement comes into existence. So we can say that agreement or promise both mean the same thing. That is, it is nothing but an offer and its acceptance, right? Agreement is also offer and acceptance. Promise is also an offer and acceptance. An agreement is promise, as I told you before. Then what is contract? Since contract is also an agreement, it involves offer and acceptance, right? Now, apart from offer and acceptance, there must be legal enforceability. I told you a contract is an agreement enforceable by law, right? So we have an agreement, we have an offer and acceptance, but it also needs to be legally enforceable, right? So for legally enforceable, it should have the essential elements of a valid contract. So essential elements means these are the things that should be present in a contract to make it enforceable by law. So in a way, this means enforceable by law. So I will discuss these elements in my next slide, right? So contract is an agreement plus essential elements. Now, two important characteristics of an agreement. First, there should be at least two parties. There can be more than two also, but at least two parties are required, because you cannot make an agreement to yourself, right? You cannot make an offer and you can't accept it yourself. That is not an agreement. Second, consensus ad idem. Remember this term, consensus ad idem. This means at the time of making an agreement, both parties agree on the same thing in the same sense at the same time. Now take an example. Mr. A agrees to sell 100 liters of oil for 10,000 rupees to Mr. B. However, Mr. A thought it's vegetable oil that he is supposed to sell, while Mr. B thought it's the hair oil which he is going to buy. So here there is no meeting of minds. Both of them thought differently. So there is no agreement. They did not agree on the same thing in the same sense. Okay. Now friends, I will make a statement here and you tell me whether this statement is correct or not. So the statement is all contracts are agreement, but all agreements are not contracts. Do you agree with this statement? Why or why not? Pause the video for a minute and think about it. Friends, this statement is correct. All contracts are agreements because a contract involves offer and acceptance, and offer and acceptance is nothing but an agreement, right? So all contracts are agreements. But are all agreements contract? No, because to become a contract, it needs to be enforceable by law also. So only those agreements that are enforceable by law are contract, right? So it is generally presumed that agreements of moral, religious, or social nature are not contracts because they lack intention to create legal obligation, right? The legal enforceability is lacking in these kind of agreements. Okay, now let's take a look at the two examples here. A promise to lunch at a friend's house. Is it a contract? Why or why not? Take a minute to think. Do you think if a person promises to have lunch at a friend's place but breaks his promise and does not go for lunch, will he be sued by his friend in the court? No, right? This is why intention to create legal relations is presumed to be absent in social or domestic agreements, right? Because social agreements are made out of love, affection, or the relationship you have with a person. You do not intend to take that person to the court, right? So similarly, let's look at another example. An agreement to buy certain goods at a certain price. Is it a contract? Why or why not again? Do you think that it is a contract that can be enforced in the court of law? Do you think this agreement is being done out of love or affection? No. This is a pure commercial transaction and parties very much intend to take the other party to the court if they breach the contract. So real legal relations are presumed in business or commercial transactions. Okay. Now very important topic. Essential elements of a valid contract. Friends, in my previous video, I told you that a contract is an agreement enforceable by law. So an agreement becomes enforceable at law when the essential elements of a contract are present in the agreement. There are 10 essential elements of a valid contract under section 10, 29 and 56. And even if a single element is missing from the agreement, it will never be enforceable and it cannot be called as a valid contract. So all these elements are very, very important and need to be present in the agreement. Okay, so the first element we have is offer and acceptance. So the very first thing towards formation of a contract is lawful offer and lawful acceptance. By lawful, I mean that the offer and acceptance must meet the requirements of Indian Contract Act 1872, which I'll be discussing later. Right? So the first element is there should be an offer and there should be an acceptance to that offer. Now, second element is intention to create legal relations. This we have already discussed in the previous lecture. So once an offer is made and it is accepted, the next thing to see is if the parties intended to create legal relation. If an agreement does not intend to create a legal relation, it cannot be called a contract and cannot be enforced in a court of law. And as previously explained, in social agreement, the presumption is that parties do not intend to create legal relations. While in business or commercial agreements, intention to create legal relations is presumed. Okay. Third important element, lawful consideration. I will explain consideration in detail later, but for now, in simple terms, consideration means when each party to the agreement gives something or gets something, right? For example, you go to a fruit seller and you buy 2 kgs of apple for 200 rupees. Now, if I have to ask you, why did the fruit seller give you his apples? Because he was getting money from you, right? And why did you pay money to the fruit seller? Because you were getting apples from him. Friends, this is called consideration. Consideration is the very reason why people enter into an agreement. Without consideration, there can be no valid contract, right? If I agree to give my watch to Mr. A, say, without getting anything in return from him, not necessarily money, but anything in return, then this agreement will lack consideration and cannot be called as a contract. So now Mr. A cannot go to the court if I refuse to sell my watch, because court will say there is no contract between two of us as there is no consideration. Okay, so consideration is an agreement is valid when each party to it gives something and gets something. For now, just remember this. Okay, fourth, capacity of parties. To form a valid contract, the parties to the contract must be competent to make a contract. Now, competent parties means must be of age of majority. That means the parties must be 18 plus years as per Indian law. You cannot contract with a minor. You cannot contract with a child, right? The parties must be of sound mind. Sound mind means they should not be mad. They should be capable of thinking in a reasonable manner. They should not be drunk at the time they are making the contract. They should not be out of their senses when they make the contract, right? Third, the parties must not be disqualified by law to contract. There are certain people who are disqualified by law from contracting, like alien enemy, ambassador and souvenirs. So I will discuss this later in my slide, but just for now, just remember these things. The parties must be in age of majority, they should be of sound mind, and they must not be disqualified by law to contract. Okay. Free consent, fifth element. As per section 13, consent means parties agree on the same thing in the same sense. When you agree on something, it is consent, right? Now, what is a free consent? Free consent means consent given by free will, right? There is no pressure on you. Free consent means consent given by free will without any coercion, undue influence, fraud, misrepresentation, mistake, right? If somebody obtains your consent, or somebody obtains your acceptance through fraud or cheating, so that is not a contract. That is not a free consent. Free consent is missing. So that contract will become void, right? So I'll explain each of these terms later. For now, just remember these 5 points: coercion, undue influence, fraud, misrepresentation, and mistake. If a contract has any of these elements, the consent is said to be obtained. The consent is said to be not obtained by free consent. Okay. Rest of the 5 elements we'll be discussing in the next lecture. So for now, just remember these 5, and the remaining 5 I'll take up in the next lecture. Thank you. Okay, so let's continue with the essential elements of a valid contract. The next one is lawful object. The object of the agreement should be lawful. As per section 23, the object is not lawful if it is fraudulent, illegal, that is against the law. If it is immoral, that is object is not as per the accepted standard of morality, or if it is opposed to public policy. Opposed to public policy means where the object of the agreement is harmful to the society. For example, agreement in restraint of trade, or agreement in restraint of marriage, or an agreement to defraud your creditors is against public policy, as it is a person's right to trade as per his choice, or to marry as per his choice. You cannot restrict this right. So these kind of agreements are called opposed to public policy. So again, the agreement should not be opposed to public policy, and the agreement should not imply injury to person or property of another. So if you agree to beat somebody, um, or you agree to break somebody's car, that is not a lawful object, right? So just remember these five points under section 23: fraudulent, illegal, immoral, opposed to public policy, or imply injury to person or property. If any of these element is present in your agreement, then your agreement will have an unlawful object and will not be enforceable in a court of law. Okay, now moving on to next element. Next element is writing and registration. Now friends, in the beginning I told you that agreement can be expressed or implied, which means even the verbal agreements can also be a contract, or an agreement or by one's conduct can also be an agreement or a contract, right? However, there are certain types of agreements required by law to be in writing only. Such agreements must be in writing to be called as valid contract, which can be enforced in a court of law, right? So, can you name any two such agreements which are required to be in writing by law? Okay, so the first one is arbitration agreement. As per Arbitration and Conciliation Act 1996, an arbitration agreement has to be in writing. Second one is an agreement for sale of immovable property. This agreement must be in writing and registered as per the Transfer of Property Act, right? So if tomorrow you verbally agree to buy a house from Mr. A and give him some token money, and later on Mr. A refuses to sell his house, you cannot go to court and enforce this contract, because court will ask to show the sale deed or the written agreement you have, right? Okay, next element. Next one is certainty, section 29. Now, the terms of the agreement must not be uncertain or vague, right? For example, Mr. A agrees to sell certain quantity of oil to Mr. B, right? So it is not clear what quantity and what kind of oil is being sold, how much quantity will he be selling, what type of oil it is. These things are not clear, right? So this is why this agreement is void, because there is no certainty. The terms of the agreement are quite loose and vague. So an agreement, the terms of the agreement have to be very certain. What are you going to do? What are you selling? What are you buying? Everything should be very clear. Then possibility of performance. So agreement to do an impossible act is void and unenforceable, for the simple reason that the agreement can never be performed successfully. Can you perform an impossible act? You can't, right? For example, Mr. A agrees to Mr. B to make his dead father alive. This agreement is not enforceable because a dead man cannot become alive, right? It is impossible. Okay, coming on to the last element. Finally, the agreement should not be expressly declared void under this Indian Contract Act 1872. There are some agreements which are expressly declared void under this act. These agreements are agreement in restraint of marriage, section 26, agreement in restraint of trade, agreement by way of wager. So the act specifically mentioned that these kind of agreements would be void. So you cannot enter into these agreements, or I should say you can enter into these agreements, but that won't be enforceable in the court of law, right? You can do whatever you want, you can make any kind of agreement, but it will never become a contract. Okay, so friends, we have come to an end of the essential elements of a valid contract. This is a very important topic. So there are 10 elements. Remember it thoroughly, go through it again, make notes, and just remember it thoroughly, because this is very important, right? There can be different kinds of contracts under this act. Let's first look at the kinds of contract from enforceability point of view, whether the contracts can be enforced in the code of law or not. Okay, so there could be three kinds of contract from enforceability point of view. The first one is valid contract, then voidable contract, and then void contract. Let's understand each one of them. Valid contract. What is a valid contract? So a valid contract is an agreement enforceable by law. That's basically the definition of the contract under section 2H. An agreement enforceable by law, right? Which means there is an agreement, and that agreement has all the essential elements of a contract, right? It has offer and acceptance, it has obligation to create legal relations, it has consideration, the parties are capable to enter into an agreement, the parties have free consent, the object of the agreement is lawful, the agreement is in writing if required by law, the terms of the agreement are certain, it is not impossible to perform, and it is not expressly declared void under this agreement, right? If all these elements are present in an agreement, it would be a perfectly valid contract enforceable by the law. Okay, so now let's discuss what is a voidable contract. Voidable contract means a contract which is not void, right? Void means invalid. So voidable contract means a contract which is not void but which can be made void at the option of the other party. Okay, so voidable contract remains a perfectly valid contract if it is not rescinded. By rescinded, I means cancellation of a contract, right? If a contract is not cancelled, it remains perfectly valid. So voidable contract has also been defined under section 2I. Remember the section 2I of the Indian Contract Act 1872. It says an agreement which is enforceable by law at the option of one or more of the parties thereto, but not at the option of the other or others. That means one of the parties to the contract will decide whether this contract is valid or this have to be rescinded. They have this right. Okay, if they don't exercise their right, the contract is valid. If they exercise their right to cancel the contract will be cancelled. Okay, generally a contract should be enforceable by both the parties or by all parties if there are more than one. However, under a voidable contract, contract is enforceable at the option of one of the parties but not at the option of other parties. Okay, now generally contract becomes voidable if the consent is obtained by um, coercion, undue influence, fraud or misrepresentation, right? In such cases, a contract is voidable at the option of the aggrieved party. So let's understand this by an example. If Mr. A puts a gun on Mr. B's head and make him sign the contract to sell his property, then this will be a voidable contract at the option of Mr. B, right? Mr. B is the aggrieved party here. So he has a right. He can go to the court and he can tell the court that I signed this contract because a gun was put on over my head and this is why I did it under coercion. Of course, coercion has to be proved. There are a lot of other things that have to be proved in the court. But on this ground, the contract can be avoided or cancelled, right? Now, there are other circumstances also when a contract becomes voidable. First is where a contract contains reciprocal promises and one party to the contract prevents the other party from performing his promise. Understand it by an example. Mr. X agrees to paint Mr. B's house for rupees 50,000. Okay, Mr. X agrees to paint Mr. B's house for 50,000 and Mr. B agrees to provide the paint to Mr. A. Right? Mr. B will provide paint to Mr. A and then Mr. A will paint the house. Mr. B did not provide the paint to Mr. A, as a result of which Mr. A could not paint the house. So this contract is voidable at the option of Mr. A. Since Mr. A could not perform his promise because of Mr. B, Mr. B prevented him from performing his duty because he did not provide the paint. If there is no paint, how would he paint the house? Right? So in such circumstances, it would be voidable. Now, um, let's look at the second example. Now, where performance is time specific but party fails to perform within the specified time. Let's take a look at the example. Mr. A agrees to sell and deliver 10 bags of rice to Mr. Z for rupees 20,000 within 5 days. It is time bound. Within 5 days. Mr. A did not deliver within 5 days. Now what will happen? This contract is voidable at the option of Mr. Z. Mr. Z can go to the, it is not enforceable. If Mr. A asks for payment or if Mr. A delivers after 5 days, Mr. Z can refuse the delivery and choose not to pay. Right? It is Mr. Z's choice now whether he wants to accept it. If he accepts it, contract remains valid. If he doesn't accept it, contract becomes void. Okay. Now, consequences when a voidable contract is rescinded. Well, when a voidable contract is rescinded by a party, Section 64 of the Act puts both the parties on the same footing as if there was never a contract at all. Right? Remember this section. Section places both the parties on the same footing as if there was never a contract. Okay. So this means if any party received any benefit under the contract, they are bound to return it to the other party. They are bound to restore it. So in the previous example where Mr. A agrees to sell and deliver 10 bags of rice. Let me go back to the previous example. Yeah. So here Mr. A agrees to sell and deliver 10 bags of rice. If any advance money is given to Mr. A by Mr. Z, then Mr. A is bound to return or restore this advance money to Mr. Z if the contract is made void. If the contract is made void, that means if the contract is rescinded by Mr. Z, Mr. A has to return the advance money to Mr. Z. Simple, right? Common sense. Okay. So this is all about voidable contract. Hope this is clear to you. Now let's discuss the third kind of contract, which is the void contract. Void contract means an invalid contract. It is an agreement which cannot be enforced in a court of law and is a complete nullity. Void contract is defined under Section 2J of Indian Contract Act. It says a contract which ceases to be enforceable by law become void when it ceases to be enforceable. Right? So from the definition of the void contract, we can infer that a void contract was perfectly valid when it was entered. However, something happens to the contract later on that makes it void. Initially it was perfectly fine, but something happens that makes it void. So what are those circumstances that make a valid contract void later on? There can be 4 reasons or 4 circumstances. First is supervening impossibility. This means a contract has become impossible to perform. For example, Mr. A is a very famous painter. Mr. B contracts with Mr. A to draw a painting for him for rupees 1 lakh. Now before Mr. A could draw the painting, he suffered a heart attack and died. In this case, a perfectly valid contract will become void as it has become impossible to perform the contract. Right? The painter has died and nobody else can perform on his behalf. Second is subsequent illegality. Again, listen to this example. Mr. A contracts with Mr. B to sell 10,000 polybags for rupees 15,000. Now after the contract is signed, but before Mr. A could sell the polybags to Mr. B under the contract, the government brings out a law which makes the sale and purchase of polybags illegal. Now the contract cannot be performed because if Mr. A sells polybags to Mr. B, it will be illegal. Hence, this contract, which was valid initially, has become void now. Okay. Third, repudiation of voidable contract. This has been discussed in my previous lecture. A voidable contract is valid unless it is repudiated. For example, Mr. A agrees to deliver 100 kgs of hair oil to Mr. B within a week. It is time bound. Okay. If Mr. A fails to deliver within a week, then Mr. B has a choice. Now, if Mr. B chooses to repudiate the contract as it was not delivered on time, the contract will become void. Okay. Fourth scenario, contract contingent upon happening of an uncertain future event if the event becomes impossible. Here contingent means dependent or conditional upon happening of an uncertain event. Understand it through an example. Mr. A agreed to give a loan of rupees 1 lakh to Mr. B if India wins the match against Pakistan. India winning the match against Pakistan is an uncertain event, right? It may happen or it may not happen. If it does not happen, suppose India loses the match, the contract will become void in such a case. Okay. Now I spoke about void contract in my previous lecture. So now let's discuss what is a void agreement. Well, the difference between void contract and void agreement is same as the difference between contract and agreement. Void agreement has never been a contract. This is why it is called a void agreement. It is void ab initio. That is, it is void from the very inception and was never given a status of a contract. While in case of a void contract, it was a perfectly valid contract when it was entered into, but later something happens that makes it void. Right? Section 2G defines the term void agreement. It says agreement not enforceable by law is said to be void. This definition is just opposite of the definition of contract given in section 2H. Section 2H says agreement enforceable by law is contract. Here 2G says agreement not enforceable by law is void. I hope the distinction between void agreement and void contract is clear. Okay, so section 65 talks something about called restitution of benefit. We discussed this in previous lecture also. Section 64 deals with the restitution of benefit under voidable contract, and section 65 deals with benefit under void or void agreement. Right? Restitution of benefit means when a contract becomes void or found to be void, then the parties to whom any benefit has been received from the other party under the contract have to restore it back to the party. Right? The objective of this provision is to put the parties on the same footing as if there has never been any contract. So, for example, if Mr. A contract to buy a house from Mr. B and gives him an advance of 1 lakh rupees and later on contract becomes void due to some reason, then Mr. B have to return the advance money to Mr. A. Okay, so I hope this is clear. Okay, so another type of void contract is unenforceable contract. These contracts are perfectly valid but still cannot be enforced in the court of law because some special legal requirement is missing. For example, Mr. A agrees to buy a house from Mr. B for 20 lakh rupees. This is perfect. This is a perfectly valid contract, right? It has a lawful offer, it has a lawful acceptance, it has consideration, it is for a lawful object, right? But it still cannot be enforced in the court of law. Why? Because the contract is not in writing. In India, sale of immovable property is required to be through a written agreement. So if an agreement is not in writing, it cannot be enforced. Such contracts are called unenforceable contracts, right? Now, what are illegal and unlawful contracts? Illegal contracts are those contracts which are against the law. In fact, these should not even be called contracts because such contracts are void ab initio. That is, these are void from the very beginning. They are merely agreements which never got any legal enforceability, right? How can an illegal agreement get a legal enforceability, right? An agreement can be said to be against the law if it is forbidden by law, if it is permitted, if permitted would defeat the provision of law, fraudulent, it implies injury to another person or property, or it is immoral or opposed to public policy. Remember these five points under section 23. All of these fall under section 23, right? So an object or an agreement would be illegal if it is covered under any of these provisions, any of these points, right? Now coming on to types of contracts from the point of view of mode of creation. There can be three types of contracts from the point of view of mode of creation. The first one is express contract. So express contracts are the contracts where the offer and acceptance are made in writing or verbally. So all written contracts are express contracts. All verbal contracts are express contracts. For example, Mr. A tells Mr. B that he will sell his car to him for 50,000 rupees. Mr. B says yes. It is again an express contract, as parties verbally agreed to do something, right? So then the second kind of contract we have is the implied contracts. Here no written or spoken words are used to enter into a contract. Rather, the contract is entered into by the conduct of the parties. Now take an example. You go to a restaurant and order food. After having food, can you say to the restaurant that you will not pay because you never said you will pay for the food? No, you can't say that. Why? Because the fact that you entered into a restaurant implies that you are there to have food on payment, right? They are not doing any charity. No spoken or written words are required to create an obligation here. Mere conduct of parties are enough for contract to be valid, right? And it is also important to note that a contract can be a mix of both express and implied contract. That is, either the offer can be express and acceptance can be implied, or vice versa. For example, you go to a shop to buy a chocolate, right? So you tell the shopkeeper that you want a Cadbury's Dairy Milk chocolate. Shopkeeper stays quiet and simply takes money from you and give you the chocolate. So here, you made an express request and the request was fulfilled impliedly by the shopkeeper without any spoken word or written words, right? Third kind of contract is quasi contract. Quasi contracts are not actually contracts, but still such contracts are treated as valid contract by law. These contracts miss some of the essential elements of the contracts, hence we cannot call them contract as such, but still law treats them as contracts. For example, section 71 of the act puts an obligation on the finder of the lost goods to return them to its true owner. This means if tomorrow you find someone's wallet on the road, then you are obligated to take steps to find its true owner. You are obligated in spite of no agreement between you and the true owner, right? In fact, you don't know the true owner, who the true owner is, right? But still, law binds you under a contract to find the true owner. Such contracts are called quasi contracts. I will discuss these quasi contracts in detail later. Okay. Okay, now let's discuss the kind of contracts from point of the extent of execution. Here we have two kinds of contract. One is executed and second is executory. Executed contract is what? Executed contract is a fully performed contract. Here all the parties have performed their share of obligations and nothing more remains to be done. For example, Mr. A agrees to paint Mr. B's house for 50,000 rupees and Mr. B agreed to provide paint to Mr. A. Mr. B provides the paint, Mr. A completes the painting of the house, Mr. B makes the payment of 50,000. This is an executed contract as both the parties have performed their obligations under the contract and nothing more remains to be done, right? Now, executory contract. Executory contract is the one where all or any of the party is yet to perform their share of obligation. It can be one party, it can be two parties, it can be all parties under the contract, right? So if we take the previous example again, if Mr. B provides paint but Mr. A has not painted the house yet, then this will be an executory contract, right? Because Mr. A is yet to perform his part of obligation. And in case Mr. B has not provided the paint to Mr. A and as a result Mr. A could not paint the house, then also it will be an executory contract because obligations to be performed are pending from both the sides, right? So this is about executed and executory contract. Hello friends, in the previous lectures we discussed about the essential elements of a valid contract. In the coming slides we'll discuss some more important legal rules for a valid offer and valid acceptance. So let's discuss the legal rules applicable on a valid offer. Some of the rules we have already discussed in the past lectures, but let's discuss each one by one. First, an offer can be express or implied. Express offer means an offer made by words written or words spoken. For example, Mr. A says to Mr. B that he is willing to sell his watch for rupees 1000. This is an express offer, right? Because he is making this offer by spoken words. Similarly, if he puts this into writing, that will also be an express offer. Okay. Now, what is an implied offer? Implied offer means an offer which is made not by words spoken or written, but by the conduct of the parties. In such case, mere the conduct of the parties is enough to form a contract, and there is no need to put the contract into writing or in words. Right? So look at this example. The State Transport Corporation runs buses at different routes to carry passengers at their scheduled fares. This is an implied offer by the Transport Corporation. So, what happens when you board a bus? Does a bus driver or conductor shout that he will drop you at so and so place for so and so amount? No. He simply stops the bus at the bus stop and the passenger simply boards the bus without saying anything. Nothing is said by words or put into writing because it is expected that the bus driver and the passengers are aware of the route and the fare set out by the Transport Corporation, and everyone will abide by the same. So you cannot give an excuse for not paying the fare saying that there was no agreement on the fare. Okay. Now the second rule, this we have discussed before also, offer must create or intend to create legal relations. Now in social agreements like agreement between husband and wife, between friends, etc., the presumption by court is that there is no intention to create legal relations. Hence agreement is not enforceable. On the other hand, in commercial or business contracts, the intention to create legal relations is presumed. It is presumed that if there is a breach, the aggrieved party will take another party to the court, right? Now, the next rule is the terms of the offer must be certain. Now, take a look at this example. Mr. A offers Mr. B lavish entertainment if Mr. B does a particular work for him. Now, what do you think about it? Can this be enforced in court? How would the court know what lavish entertainment means? It can be anything. Similarly, what is meant by particular work? Again, it can be anything. How would court help in such cases where the terms of the offer are totally vague? So such offer is not valid. To be a valid offer, all material terms of the offer must be clearly stated and clearly agreed to. Okay. Now, moving on to the next rule. This is a very important rule and often asked in examinations. An invitation to offer is not an offer. So what happens? Sometimes a party may disclose some information and invite others to make an offer based on the information disclosed. This is called invitation to offer and it is not an offer, right? So let's understand this through an example. So what happens in an auction? Say someone gives an advertisement in the newspaper to sell off his vintage car by way of auction. The advertisement describes about the car, like how old it is, what are the features, any special connection with the history, etc., etc. Right? Such information will help the readers to decide if it's really worth participating in the auction, worth bidding for that car or not. So this advertisement itself is not an offer, but just an invitation to offer. The advertisement is giving information and inviting people to make an offer, right? This is what we have, now you make an offer. So the advertiser can always decide to not hold the auction, and the reader cannot say that he has accepted the offer of holding an auction and now the advertiser must hold the auction, right? No, advertiser is not bound to do that, because an advertisement of holding an auction is not an offer, right? But it is just an invitation to offer. Actual offer will be made by the people who bid in the auction, and when this bid is accepted, it will become a contract. So somebody gives an advertisement and just then takes it back, that doesn't mean that he has, he has breached his offer. No, because that's not an offer at the first place. Another example, if you take display of goods with price tag. Suppose you go to a supermarket, you see a beautiful pair of shoes with a price tag of rupees 5,000. You pick that up and go to the billing counter. The guy at the billing counter refuses to sell this shoe to you, and he tells you that for so and so reason this pair of shoe cannot be sold. Now you cannot bind the supermarket under the contractual obligation saying that price tag on the shoes amounted to offer, which you have happily accepted, right? The price tag on the shoes is only an invitation to offer. It's not an offer. Actual contract will come into existence when you pay for the shoes and the guy at the supermarket accepts your payment. Then the contract will come into force, right? Similarly, another example, if I take tender. So what happens in a tender? Often companies outsource their work to third parties. They roll out a tender which specifies type of work, scope of work, method of payment, and other relevant information. These tenders are invitation to offer. The company is just providing information in the tender to the third parties to help them decide if they really want to take up this work. The company is merely inviting third parties that this is the work and these are the relevant details. If you are interested, make us an offer. If we like your offer, we will accept it and the contract will come into existence. As simple as that. Okay. So rest of the rules we'll be discussing in the next video. Alright, let's come on to the next rule. So next rule is an offer may be specific or general. By specific offer, I mean an offer which is made to a specific person or persons or a specific group of persons. For example, I make an offer to Mr. A. It is a specific offer which is made to Mr. A. If I make an offer to Mr. A and Mr. B, it is still a specific offer because it is directed towards Mr. A and Mr. B. And if I make an offer to all the employees of XYZ company, that will still be a specific offer because it is made only to the employees of XYZ company and no one else. Okay. Now, what is a general offer? General offer is an offer which is made to the public at large, right? So there is a famous case law for this general offer. This case is called Cargill versus Carbolic Smokeball Company. In this case, Carbolic Smokeball Company advertised to the public that anyone who contracts influenza after having used their smoke balls 3 times a day for 2 weeks as per the printed directions will be paid £100 by the company. So this Mrs. Carlyle, on the faith of this advertisement, bought and used the smoke balls as per the written directions and still contracted influenza. She sued the company to claim her £100 and the company was held liable. So the company making advertisement is making a general offer to the public at large, right? It's an offer to anybody who's reading that offer, and accordingly there is a contractual relationship between them. Okay, so these general offers may be continuing one or it may be a limited one. For example, in the case of Carbolic Smokeball Company, the offer was a continuing offer. So if next time anyone else contracts influenza after using their smoke balls, the company will be held will be liable to pay again, right? So there can also be some situations where the offer may not be continuing. For example, um, police makes an offer to anyone who catches Mr. X, a notorious criminal, and they keep a reward of rupees 10,000 on his head. So here only the person who catches Mr. X will be rewarded, and then the offer will be closed. So it's not a continuing offer, unlike the one in Carlyle versus Carbolic Smoke Ball Company. Okay, let's move on to the next one. Okay, offer must be communicated to offeree. Friends, as you know, to form a contract, there should be an offer and its acceptance. Now, how can you accept something which you are not aware of? You simply can't. There can never be a valid acceptance if you are not aware of the offer, and thus there can be no contract. So take this example. Mr. B catches a criminal on whom a reward of rupees 50,000 was announced by the police. However, Mr. B was not aware of this reward. Here Mr. B cannot recover the award as he was not aware and there was no contract. Right? So when Mr. B is not aware of the contract, how can he accept the offer? He is not even aware of the offer. Right? So the acceptance part is missing in this transaction, and hence there is no contract. And there is a famous case law here also. I'll just go through this one. The case is called Lalman Shukla versus Gauri Dutt. In this case, the nephew of the defendant absconded from home. Defendant sent his servant to search him. After the servant left to search the nephew, the defendant announced a cash reward. Before servant became aware of the offer, right? So before servant became aware of the offer, he found the nephew and informed the defendant. Later, when the servant came to know about the offer, he asked for his cash reward, which defendant denied. So it was held that the servant cannot deem to have accepted the offer as he had no knowledge about the offer. Hence, defendant was not liable to pay the cash reward to the servant. Right? Same case, you are not aware of the offer, so you cannot accept the offer. And if you cannot accept the offer, there can be no contract. As simple as that. Okay, moving on to the next one. An offer should not contain a term the non-compliance of which amounts to acceptance. Friends, just imagine if a man writes a letter to Katrina Kaif stating that he wants to marry her, and if she doesn't respond back within 3 days, he will assume that Katrina Kaif also wants to marry him. How does that sound? Funny, right? Friends, the offeree cannot be obligated to respond to the offer. If there is no response from the offeree, there is no acceptance and hence no contract. Simple rule. Okay. Okay, and an offer can be subject to any terms and conditions. Well, offerer can attach any terms and condition to his offer. Obviously, it should be legal, but he can attach any terms and conditions to his offer. And those terms and conditions needs to be complied with by the offeree for the contract to come into existence. Okay. Offerer may also prescribe the mode of acceptance of the offer, and that needs to be complied as well by the offeree. So, in case of deviated acceptance, what is deviated acceptance? For example, in cases where the offeree uses a different mode of acceptance that was prescribed by or that was prescribed on the offer. For example, the offer said the acceptance to be sent via telegram, whereas the offeree sent the acceptance via post. So this is a case of deviated acceptance. In this case, the offerer may choose to decline the acceptance as valid acceptance, provided, very important point, provided he gives a notice of the same to the offeree of such deviated acceptance. If he does not give any notice, the offerer is deemed to have accepted the deviated acceptance, right? So if somebody accepts your offer in a different mode than what you have prescribed, then it is your choice whether you want to accept it or you want to reject it. If you want to accept it, that's fine. If you want to reject it, then you must give a notice. You must inform the offeree that I am rejecting your acceptance because it is in a mode other than the one prescribed. Okay. Next rule. Two identical offers do not make a contract. If two or more parties make an identical offers to each other in ignorance of each other's offer, then it will not form a contract, right? So the offer should be identical, it should be made at the same time, and it should also be in ignorance of each other's offer. They both should not be knowing that the other person is also making the similar offer, right? So take an example here. Mr. A writes a letter to Mr. B offering to sell his car for 1 lakh. At the same time, Mr. B, who is not yet aware of Mr. A's offer, he doesn't know about Mr. A's offer. He also writes to Mr. A offering to purchase his car for rupees 1 lakh. Then there is no contract. You cannot say that they both agree on the same thing, so it's a contract. There is no contract because there is no acceptance. Both of them have made an offer, but nobody has accepted it, right? So two identical offers do not make a contract. Okay. All right, people. Now we'll be discussing some rules relating to lapse of the offer. I'll explain you under what circumstances a valid offer can lapse. So let's get started. First, an offer lapses after stipulated time or reasonable time. So there are two things here. First, when the offer prescribes a time limit within which it must be accepted. For example, Mr. A offers to Mr. B to sell his watch for rupees 500, and if Mr. B is interested, he must give his acceptance within 7 days. Now Mr. B does not respond within 7 days. In this case, offer lapses. Here Mr. B cannot give its acceptance on 8th day because offer is no more valid. Alright. Now second situation. Offer is sent by telegram which states that acceptance is required urgently. Here there is no time limit prescribed. So in such cases the law will go by what is called as reasonable time. So what will be considered the reasonable time here? The offer is sent by telegram and the urgent acceptance is asked for. So here even a delay by a single day will lapse the offer. So what is reasonable time will depend upon facts and circumstances of each case. Alright. Now the offer lapses if not accepted in the mode prescribed or in a reasonable manner if no mode prescribed. We have just discussed this before. If the offer is not accepted in the mode prescribed, the offerer has to provide a notice to the offeree that his acceptance is not in the mode prescribed, and if he still does not provide his acceptance in the correct mode, the offer lapses. Okay. An offer lapses by rejection. You make an offer to a person and that person rejects your offer, then your offer lapses. Now, rejection of the offer can be express or implied. Express rejection means when offer is rejected by spoken words or written words. It can also be implied rejection, that is rejection of an offer by the conduct of the parties. Can you think of some examples of implied rejection? Just think over it. Well, one case could be where the offeree, that is a person whom offer is made, makes a counter offer. In this case, the original offer lapses. For example, Mr. A writes to Mr. B offering to sell his motorbike for rupees 30,000. Mr. B writes back stating that he is willing to buy the motorcycle for rupees 20,000. Here the original offer of selling the motorbike for 30,000 lapses and a new offer by Mr. B for buying motorcycle for 20,000 comes into existence. Right? Another case of implied rejection could be where the offeree gives a conditional acceptance. For example, Mr. A offers Mr. B to draw a painting for him for rupees 50,000. Mr. B in turn says that he will draw the painting for rupees 50,000 if Mr. A gives a job to his son in Mr. A's company. This is called conditional offer and the original offer here is lapsed. Okay. An offer lapses by death or insanity of the offerer or offeree. According to section 6 subsection 4 of the Indian Contract Act, if the offerer dies or becomes insane before the acceptance of the offer lapses, provided, very important point here, provided the fact of the death or insanity of the offerer comes to the knowledge of the acceptor of the offer. Right? This means if the acceptor is not aware of the death or insanity of the offerer and accepts the offer remains perfectly valid. On the other hand, if the offeree dies or becomes insane, the offer lapses because there is no one who can accept the offer except the offeree himself. Offeree here cannot accept the offer. Okay. There are a few more rules relating to lapse of offer which we'll be discussing in the next lecture. Okay. All right. Continuing with our rules relating to lapse of offer. The next rule is an offer lapses by revocation. An offer is revoked when taken back by the offeree before its acceptance. Right. So you send an offer to Mr. B via post. Mr. B could read your letter and accept it. You called him up telling him that you are taking back the offer you sent via post to him. Here the offer stands revoked, right? It is important to note that revocation must be communicated or made known to the offeree, otherwise revocation will not be valid. And revocation of a general offer made to public at large must be made through the same channel through which general offer was initially communicated. For example, if you make a general offer to the public through newspaper and later you want to revoke that offer, then you must bring the notice of revocation to the public through newspaper only. Okay. Next one we have is revocation by non-fulfillment of condition precedent to acceptance. Sometimes an offer may contain a condition which needs to be fulfilled before it can be accepted. In such cases, the condition must be fulfilled before offer could be accepted. If the condition is not fulfilled, the offer will stand revoked. Right? For example, Mr. A agrees to sell his house to Mr. B if Mr. B finds him a new house within a week. So the condition here is that Mr. B has to find a new house within a week. Mr. B fails to do so. The offer stands revoked, right? Since Mr. B could not fulfill the condition, the offer stands revoked. Okay, next is offer lapses by subsequent illegality and destruction of the subject matter. Friends, an offer can also lapse on two grounds, right? First, if the offer was initially valid and legal when it was made, but something happens before its acceptance that makes the offer and its acceptance illegal. In such cases, offer cannot be accepted as it will be illegal and the offer stands revoked. For example, Mr. A offers to sell 1000 poly bags to Mr. B for rupees 5000. Now, before Mr. B could accept the offer, the government puts a ban on the sale and purchase of polybags. In this case, the offer has become illegal and cannot be accepted. So the offer here stands revoked, right? Second case, if the subject matter of the offer is destroyed, the offer is revoked. For example, Mr. A offers to sell his factory to Mr. B for rupees 5 lakh. Before Mr. B could accept the offer, fire breaks out in Mr. A's factory, completely destroying the factory. In this case, again the offer stands revoked as the subject matter of the offer, which is the factory in this case, does not exist anymore, right? Factory is completely destroyed and there is nothing to sell now. So obviously offer will stand revoked. All right. In the next lecture, we'll be discussing rules relating to valid acceptance. So see you in the next lecture then. Now some rules relating to valid acceptance. So the first rule is that acceptance of an offer must be given by the person to whom it is made. Now this is quite self-explanatory. Imagine someone asks you if you will buy a mobile for 5000 rupees and your friend sitting with you says yes, he will buy. Does it make sense? The decision to accept or reject the offer lies with the offeree only. Only you can decide whether you want to buy that mobile for 5000 rupees or not. No one else on your behalf can accept the offer. Okay, but this is the case where the offer is made to an individual. But what about a situation where offer is made to a class of persons? For example, bar association starts a clubhouse for lawyers and inform all the lawyers that whoever is interested in becoming a member of the club can pay the fees and avail the benefits of membership. So now this offer is valid for all the lawyers. It can be accepted by any lawyer of that bar association, and a non-lawyer or a lawyer from another bar association cannot accept this offer. Okay. Now third situation is when an offer is made to public at large. For example, a state police advertises in the newspaper that whosoever captures this particular dreaded criminal will be rewarded 50,000 rupees. Now Mr. A captures this dreaded criminal and handed over to the police, but he was not aware of this offer of 50,000 rupees. In this case, he cannot claim this reward. Why? Because when if he is not aware of the offer of 50,000 rupees, then how can he accept the offer? And when he has not accepted the offer, how can he claim the reward? Right? If he was aware of the offer, then capturing the criminal and handing him over to the police would have amounted to implied acceptance, and Mr. A could have claimed the reward of 50,000 rupees. Right? So it is important that person to whom offer is made is actually aware of the offer and accepts it. All right? Make sense? Let's move on to the next rule. So the next rule is that the acceptance must be absolute and unqualified. This means that the offeree should accept the offer as it is without any variation or conditions attached to it. Let's take an example from our day-to-day life. You're walking by a road and this fruit seller calls you and offers you to sell his mangoes for 100 rupees per kilogram. Now you agree to buy the mangoes, but you tell him that you will buy 2 kgs if he sells you for 80 rupees per kilogram. So in this case, there is no acceptance of the offer because you have not accepted the offer as it is. The offer given to you was to buy mangoes for 100 rupees per kg. You agreed to buy, but you attached a condition of buying more quantity at a lesser price. In fact, a new offer from you to the fruit seller has now been made, and the old offer from the fruit seller stands revoked. I hope this is clear. Let's move on to the next one. Alright, so the next rule is acceptance must be expressed in some usual and reasonable manner unless the proposal prescribes a manner in which it is to be accepted. Usual and reasonable manner means acceptance must be expressed in a way a common and a sane person would normally express. For example, Mr. A offered Mr. B to sell his car for 2 lakh rupees. Mr. B claps twice to signify his acceptance. Do you think this is a usual and reasonable manner to accept? Would a common and a sane person accept an offer like this? No, right? How would Mr. A know what does clapping twice mean? Whether it is a yes or it is a no. This is why acceptance should be expressed in some usual and reasonable manner. But there is one slight exception. In the previous example, if Mr. A offers to sell his car to Mr. B and Mr. A further asks Mr. B to signify his acceptance by clapping twice and Mr. B do so, then this will be a valid acceptance. Why? Because the offer itself prescribes the manner in which offer should be accepted. So even if an offer prescribes a weird mode of acceptance, it is perfectly valid. All right. So the next rule is acceptance must be communicated by the acceptor. Friends, the first rule we learnt about in the beginning was that the acceptance of an offer must be given by the person to whom it is made, right? Now this rule says not just it has to be accepted by the person to whom it is made, but it must also be communicated by him or someone authorized by him. Let's understand it through an example. Mr. A offers to supply 1000 office chairs to XYZ company. Okay. Mr. B, who is an employee of XYZ company, tells Mr. A that his company accepts the offer. Do you think this will be a valid contract? No, because Mr. B had no authority to accept. He's just an employee of the company.
offer must be accepted by the directors or the authorized person of the company. So in this case, communication of acceptance does not come from the right acceptor, and hence the contract is not valid. I hope this is clear. Now the next rule is that the acceptance must be given within a reasonable time and before offer lapses or revoked. In order for acceptance to be valid, acceptance must be given within the time stipulated in the offer, or if no time is stipulated, then within a reasonable time. What is reasonable time will depend on case to case basis. For example, Mr. A offers to sell his house to Mr. B for 50 lakh rupees on 1st of August 2019. Mr. B does not respond. Then one fine day on 10th July 2020, next year, Mr. B says he accepts the offer. Now Mr. A says he does not want to sell his house, but Mr. B insists that he made an offer and he accepted the offer, so it's a valid contract. So what do you think, friends? Is Mr. A bound by the contract? The answer is no, because Mr. B responded after 14 months, which is much beyond the reasonable time required to accept such offers. To know what is a reasonable time to accept the offer, one has to look into the time taken to accept similar offers in the market. How much time people normally take to accept such offers, right? 14 months is, way too long to accept offer of selling house. Now, also, the acceptance cannot be given if the offerer revokes his offer after some time. For example, Mr. A offers to sell 100 quintal of rice to Mr. B for 25,000 rupees. Before Mr. B could accept the offer, Mr. A revokes the offer saying he no longer wants to sell. In such a case, offer cannot be accepted by Mr. B and Mr. A is not bound to perform under the contract. So if you revoke something before it is accepted, that is valid. You don't need to perform the contract. Similarly, if Mr. A gives an offer to Mr. B and before Mr. B could accept, Mr. A goes insane or say Mr. B dies, then the offer cannot be accepted by Mr. B, right? Let's move on to the next rule. Okay, so the next rule is acceptance must succeed the offer. This is quite self-explanatory. This means first there should be an offer and then acceptance should follow. You cannot accept something if there is no offer made to you, right? You cannot accept something on your own unless somebody actually offers that to you. Okay, and then the final rule, the last rule is rejected offer can be accepted only if renewed. This means an offer once rejected cannot be accepted again unless a fresh offer is made. For example, Mr. A makes an offer in writing to sell Mr. B 200 kgs of apple for rupees 10,000. Mr. B writes back saying he is not interested. Later, Mr. B sends another letter saying he accepts the offer. Now, this acceptance is not valid because he has already rejected the offer, and in order to give a legally valid acceptance, Mr. A needs to make an offer again, and then Mr. B has to accept it again. Okay, so that brings us to the end of valid rules relating to acceptance. In the next slide, we'll be discussing about one of the most important topic of law of contracts, which is consideration. Okay, so let's move on to the next topic. Alright friends, so this brings us to the end of part 1 of Law of Contract in India. I hope you found it useful. Do watch part 2 of this course for the complete Indian Contract Act 1872. Part 2 is a paid course and runs over 5 hours of duration. Part 2 covers the entire Indian Contract Act in detail, explained in a very simple way. So if you like this course, do check out part 2 as well. I have pasted the link for the course in the description of this lecture. And I thank you all for taking time to complete this course and wish you the very best.